Rules regarding pets, Airbnb, and common areas can stir up disputes between owners, landlords, and building managers. To answer some of the most common legal issues, the founder of Lash Condo Law, Denise Lash, joins us now. Good to see you.
Nice to see you, too.
So we have some scenarios. We want to run through some hypotheticals. I want to start with pets. People obviously have a deep connection to the pets that they have. What about this scenario? Someone moves into a condo, they have a dog. They think it's all right. They've seen them in the lobby, and then they get a notice from the building management that you're not supposed to have pets in this building. What's your recourse? What can you do?
Yeah, it's a common problem. And I think one of the issues that a lot of condo owners have is that they don't read the documents. And then they get into these problems. They get into trouble. First thing you do when you buy a condo is that you have to read the condo docs. And if you read the condo docs, you'll see whether there are pet restrictions. Oftentimes, there may be restrictions on pets, whether you can have a dog or no dog, whether you can have 2 dogs, 1 dog, a dangerous dog, or 30-pound dogs. You know, that has to be under a certain weight. So it's really important to look at that. If you go and you are looking at a unit and you see other dogs, doesn't necessarily mean that you can have it yourself.
So that's no defense.
Well, it's no defense. It may be other reasons. It may have been that rules were enacted afterwards. So these pets are called grandfather pets. And they're allowed to stay, but you're not allowed to keep yours. Okay,
we're going to throw a Renos scenario at you. Say someone said, I recently renovated one of my washrooms in my unit, but now I learned I needed to get the board's approval before doing so. Is this correct?
Oh, see, that's a big one, because I think people think when they have their unit, they bought their suite, that they could do what they want inside their suite, and that's not necessarily the case. As soon as you make any alterations, you could be going into the common elements, which is not part of your units. And there may be restrictions, again, in the documents. So you have to see, because you may not be able to do those things in your unit. And if you do, you may have to remove it. So it's wise to check with management before you do a renovation, see what's required.
Yeah, fancy yourself a handyman and a plumber. Don't get under that sink without checking if you're allowed under there. Next one, short-term rentals. This is obviously a very hot topic. Say this is the scenario. I want to advertise my unit on Airbnb when I'm away this summer. I've been told that I can't, and if I do, I may get in trouble with the board. I may just do it.
Yeah, you know, a lot of people just do it. You know what happens? They get a legal letter, and then they have to pay $500 to $600. And if they keep doing it, they may end up in court or in a mediation. So you're better off not doing it. You have to look at your documents again to see whether you are permitted to do it. Most condominiums do not permit that short-term tenancy, and it is a big issue lately. So don't sneak around and do it, because you'll find yourself with a hefty legal bill.
A hefty legal bill. It probably won't, the Airbnb fee that you collected probably won't make up for it. Next scenario, access to a unit. Say here, I work at home in my suite. I'm a very private person. I received notice from management that someone will be entering my unit next week to change filters in my HVAC unit. Can they just enter when they want and I can't say no?
You know, a lot of people work out of their units, and so they want their privacy, but they have to understand that there's something called the Condominium Act. Condominium Act gives management the ability to go into units. And they have to give notice, so they do require 48 hours notice unless it's an emergency and they get in. You can't prevent the corporation through its manager coming into the unit. Otherwise, you'll be getting another lawyer's letter and you'll have to pay those fees.
Now, is there an understanding, though, that maybe there's certain times that don't work for the tenant and something can be brokered, or at some point does that process break down? They say, listen, we're coming in anyway.
Well, they'll usually provide you with notice. If the time doesn't work, then you could try to see whether there's another time, but you do have to provide access, so you don't have to be home. And if you don't provide a key and you don't provide access, and that's the only time that they can come in, the corporation can technically go in and knock down the door, and then you're going to be paying the costs.
To put the door back up. Okay, that's good to know as well. Our next scenario, common expenses. This is a big one in condos. This one, say, our whirlpool is not working and the elevators are constantly having problems. I'm fed up. I've decided that I will deduct certain amounts from my monthly common expenses until everything is in working order. Is this something someone should be taking on?
Never, because it's one of the fundamental obligations of all condo unit owners is to pay their common expenses. It's in your documents, and it has to be paid. Regardless of whether you use the pool or you don't use any of the amenities or something is broken, you still are required to pay it. And if you don't pay it, then there's going to be a lien that's registered against your unit. Could be a couple $1,000s.
So another serious consequence. Our last scenario here, common elements. This one actually sort of reminds me of something else. I want to place a floor mat outside my front door, hang some door decorations. My neighbors say I can't do that. Why? Bringing suburban living to the condo.
It sounds reasonable.
Yeah.
You know, you want a floor mat. You don't want your guests traipsing in with dirt over into your unit. Or maybe around the holiday season, you want to put a wreath on your door. You can't do it unless, of course, there's something in the rules that allows you to do it. It's a common element, which means everybody owns it. It's not your property for you to do something that you choose to do.
In terms of you and I were discussing earlier, there's been some changes in the condo space as well in terms of legislation and the law, and you said it's made things rather busy. What are some of those changes that we've seen?
Well, there's going to be a lot of changes, and we're anticipating that in July there's going to be a whole overhaul of the Condominium Act. Right now, there are a lot of stakeholders that are providing input to the ministry. So we'll have to see what they end up doing, but there will be a condo office and there will be a tribunal. We are anticipating that that will help a lot of condo owners who right now don't have a place to go for certain minor things, like wanting a copy of records and not knowing. So they will be able to go to this condo office.
I've only got about 30 seconds left with you. I want to ask you, when people don't like the fees themselves, can they challenge those, get them bought down?
No. Well, the condo fees are set by the developer. When they create the condominium corporation, they set your proportion. The budgets change every year. It depends what the expenses are for your condominium corporation and what the board decides it wants to do. You want additional security, it's going to increase your costs.
All right. Well, thanks. Very fascinating stuff.
Okay, thank you.
Denise Lash, founder of Lash Condo Law. That's all the time we have for House Money this week, but as always, we'd love to hear from you. You can send us an email at housemoney@bnn.ca, or you can tweet us at BNN House Money, or tweet me directly at Greg Bennell. Give us your show ideas and give us your thoughts on what you just saw. Thanks for watching, and stay tuned for more here on BNN.